From 2000 to 2025, Texas planned to execute many prisoners. Most of those executions happened, but a few didn't. Some inmates were saved by judges. Others had their sentences changed. This video covers every case where an execution in Texas was stopped. Here's the full list. Thomas Whitaker, 2018. Thomas Whitaker was sentenced to death for orchestrating the murder of his own family in 2003. He planned the killings to claim inheritance money, recruiting a friend to ambush his parents and younger brother at their home in Sugar Land, Texas. His mother and brother were shot and killed, while his father, Kent Whitaker, survived the attack. Though Thomas did not pull the trigger, prosecutors argued that he was the mastermind. In 2007, he was sentenced to death, but in a stunning turn, his father, also a victim, and a surviving family member, begged the Texas Board of Pardons and Paroles and Governor Greg Abbott to spare his son's life. Kent believed in his son's redemption and said that another execution would only extend the family's pain. Just minutes before Thomas's scheduled execution on February 22, 2018, Governor Abbott accepted the board's unanimous recommendation and commuted his sentence to life without parole. It was the first time Abbott granted clemency in a death penalty case. The case drew national attention because of its moral and legal complexity. A father forgave his son's betrayal and fought to save his life. The system, rarely known for compassion in such brutal cases, actually listened. Abbott emphasized that the actual shooter had received a lighter sentence and that Thomas's rehabilitation efforts in prison helped sway the decision. Thomas Whitaker remains in a maximum security prison for life, never eligible for parole. His story stands as one of the most extraordinary examples of clemency in Texas death penalty history. Not because he was innocent, but because forgiveness and a father's love stopped the system just in time. Will Spear, 2023. Will Spear was scheduled for execution in Texas on October 26, 2023. He had been convicted of murdering a fellow inmate in 1997, while already serving a life sentence for a separate homicide. His crime placed him among the most dangerous inmates in the Texas prison system, and he was sent to death row shortly after. But just hours before his scheduled execution, the Texas Court of Criminal Appeals issued a stay. The decision was based on newly raised issues about ineffective legal representation and allegations of prosecutorial misconduct during his original trial. One of the key claims was that Spear had not been given a fair chance to defend himself. His attorneys argued that crucial evidence and mitigating factors were never properly presented to the jury, details that could have influenced whether he received a death sentence or life imprisonment. Additionally, Spear's advocates highlighted his transformation behind bars. Over the years, he had become a committed Christian, worked with prison ministries, and mentored other inmates. Supporters said his rehabilitation showed he was no longer the same man who committed the violent act decades earlier. The court's decision to halt the execution was not a commutation, but a pause to allow further legal review. It signaled that even in cases involving violent prison killings, the courts are willing to revisit old convictions when fairness is in question. Will Spear's fate is now in limbo. The system that once condemned him to die is now re-examining whether that sentence was just, or if his transformation and the failures of the past demand a second look. Juan Segundo, 2018. Juan Segundo was convicted of a 1986 rape and murder in Fort Worth, Texas. His case was one of the earliest linked to a suspect through DNA evidence, when cold case detectives reopened the file in the early 2000s. Juan Segundo broke into homes and took the lives of multiple victims, including 11-year-old Vanessa Villa in 1986. DNA evidence later tied him to 3 more murders, all involving rape. Once his DNA matched evidence from the crime scene, Segundo was arrested and sentenced to death in 2007. His execution was scheduled for October 10, 2018. But as the date approached, Segundo's legal team raised a significant claim that he was intellectually disabled and therefore ineligible for the death penalty under U.S. Supreme Court rulings. Texas has historically applied a narrow standard for determining intellectual disability in capital cases, but recent legal developments required the state to reconsider how those determinations were made. Segundo's attorneys argued that his low IQ scores, poor adaptive functioning, and developmental issues qualified him as intellectually disabled. The Texas Court of Criminal Appeals granted a stay just weeks before his scheduled execution. The decision was rooted in the need to reassess whether Segundo's condition exempted him from capital punishment under the evolving legal definition of intellectual disability. This case highlighted Texas's shifting stance on how to evaluate mental capacity in death penalty cases. Doyle Lane, 2007. Doyle Lane was sentenced to death for one of the most disturbing child murders in Texas history. In 1980, 8-year-old Bertha Martinez was abducted from San Marcos. Her body was found in a field not far from her home. She had been assaulted and strangled. The brutality of the crime shocked the local community, and Lane was arrested shortly after. He had a prior record and lived nearby, making him a suspect early on. At trial, prosecutors presented testimony from a jailhouse informant and circumstantial evidence tying Lane to the scene. There was no physical evidence directly linking him to the crime, but the jury was convinced. In 1981, Lane was found guilty and sentenced to death. For years, his legal team filed appeals claiming that he had significant mental impairments and never received a fair trial. As death penalty law evolved in the 2000s, Lane's defense pushed harder on claims that he was intellectually disabled. This argument gained traction after the U.S. Supreme Court ruled in Atkins v. Virginia, 2002, that executing people with intellectual disabilities was unconstitutional. Lane's lawyers presented school records, IQ scores, and expert testimony that pointed to clear developmental delays and cognitive issues dating back to childhood. In 2006, a district court in Hays County reviewed the evidence and agreed that Lane met the legal definition of intellectual disability. The Texas Board of Pardons and Paroles unanimously recommended commuting his sentence. On March 9, 2007, Governor Rick Perry signed off on it, officially sparing Lane from execution and converting his sentence to life in prison. Emmanuel Kemp, 2018. Emmanuel Kemp was sentenced to death for the 1987 murder of a woman in Fort Worth, Texas. The case centered on the killing of a local woman during a violent robbery, and the prosecution's case leaned heavily on the testimony of a single eyewitness. Despite the absence of physical evidence linking Kemp to the crime scene, he was convicted and sent to death row. His original execution date was set for November 7, 2018. But as that date approached, new questions emerged about the strength of the evidence used to convict him. Kemp's defense team filed a motion requesting DNA testing on evidence that had never been analyzed before. They argued that modern forensic science could either confirm his guilt or potentially exonerate him. The Tarrant County District Attorney's Office agreed to the testing, a rare move in a case that had stood for over 30 years. Because of that decision, the scheduled execution was withdrawn to allow time for the tests to be completed. The case highlighted how older convictions, especially those based on minimal or shaky evidence, can still face scrutiny even decades later. David Leonard Wood, 2025. David Leonard Wood, sometimes referred to as the Desert Killer, was sentenced to death in 1992 for the murders of 6 young women in El Paso, Texas. The killings took place over the summer of 1987 when the bodies of the victims were found buried in shallow graves in a desert area near northeast El Paso. All 6 women had been reported missing months earlier. They were between the ages of 13 and 24. The murders caused widespread fear across the city. Wood was a convicted sex offender who had recently been released from prison at the time of the killings. He became the main suspect when several witnesses placed him with the victims around the time they disappeared. During a separate jail stay, another inmate claimed that Wood had confessed to the murders while behind bars. Investigators used this information and built a case based mostly on circumstantial evidence and Wood's criminal history. Despite the lack of physical evidence directly linking him to the crime scenes, Wood was charged and convicted of capital murder. At trial, prosecutors leaned heavily on witness testimony and emphasized his past violent offenses. In 1992, he was sentenced to death and began what would become a decades-long fight on death row. In March 2025, just 2 days before he was set to be executed, the Texas Court of Criminal Appeals issued a stay. The court didn't publicly explain its reasoning, but it allowed more time to examine his final appeal, which included claims of ineffective legal representation and possible flaws in the case. As of now, David Leonard Wood remains on Texas death row, more than 30 years after the crimes. His case remains one of El Paso's most disturbing and long-running capital cases. Robert Roberson, 2024. Robert Roberson was sentenced to death in 2003 for the death of his 2-year-old daughter Nikki Curtis in Palestine, Texas. Prosecutors argued that Roberson violently shook the child, causing fatal injuries, a case of what was then called shaken baby syndrome. Roberson denied harming her and insisted she fell from bed while sick with a fever. At the time, medical testimony helped secure his conviction, but in the years that followed, new scientific research cast doubt on the reliability of shaken baby syndrome diagnoses. Multiple experts began challenging the assumptions used in such cases, and Roberson's attorneys used this new science to argue for a re-examination of his case. In 2024, just months before his scheduled execution, the Texas Court of Criminal Appeals granted a stay. His legal team presented new medical evidence suggesting that his daughter may have died from undiagnosed pneumonia and a pre-existing head injury, conditions that could have explained her symptoms without the need for foul play. The court agreed that these new findings deserved further review and halted the execution while it considered whether Roberson's conviction should be overturned or his sentence changed. His case sparked national interest because it called attention to how flawed medical testimony can lead to wrongful convictions, especially in emotionally charged cases involving children. Critics said the state moved too quickly to assign blame without fully understanding the medical facts. Roberson remains on death row, but his execution is now on indefinite hold. Brittany Marlowe Holberg, 2025. Brittany Marlowe Holberg was sentenced to death for the 1996 murder of 80-year-old A.B. Towery, a retired man living alone in Amarillo, Texas. At the time, Holberg was just 23 years old and addicted to drugs. Prosecutors said she entered Towery's home under the guise of needing help, then brutally attacked him. He was stabbed nearly 60 times with a knife, fork, and scissors, beaten with a hammer, and left dead in his own living room. It was a violent and personal crime that shocked the community and earned her a death sentence in 1998. At her trial, Holberg didn't deny being at the scene, but her defense argued that she acted in self-defense during a struggle. That argument didn't sway the jury. Her past, including arrests for prostitution and drug possession, was used against her. The jury returned a guilty verdict and gave her the death penalty. Over the years, Holberg's case gained national attention not just because of the crime but also because she was a woman on death row, a rarity in Texas. For more than 2 decades, Holberg fought her conviction through multiple appeals. She claimed ineffective counsel, prosecutorial misconduct, and unfair bias based on her lifestyle and gender. Her legal team also argued that important mitigating evidence like her history of abuse and trauma was never properly presented during her original trial. These issues lingered in the courts for years, gaining more traction in recent appeals. In 2025, the U.S. Court of Appeals ruled that Holberg's original sentencing had been compromised by errors and a failure to present key mitigating evidence. Her death sentence was overturned. Though her conviction for murder still stands, she was resentenced to life in prison without the possibility of parole. Holberg remains in custody, but her removal from death row marked the end of a long and contentious legal battle. Every case in this list shows how complex the death penalty really is. Some inmates were spared because of legal errors. Others had powerful people speak up for them. A few may have been innocent, or at least deserved a second look. And in rare moments, even the state of Texas hit pause. No matter how you feel about capital punishment, these stories remind us that justice isn't always black and white. Mistakes happen, minds change, and sometimes, mercy shows up in unexpected ways. Thanks for watching. If you want more videos like this, hit subscribe and check out our playlists for more real stories from death row. See you in the next one.